Morning everybody and welcome to July's Employment Coffee Break briefing. Today we are going to be looking again at a final part of the Employment Tribunal. It follows on from the previous three sessions and we'll also draw today slightly on the mock tribunal event that the team here at Friends hosted last month. For those of you on the call who were able to attend, thank you for coming. We thought it was a fantastic event, the feedback's been great. For those of you who weren't able to, sorry you missed out. Like I say, it was a really good event. We all thoroughly enjoyed it, and I'm hoping everybody who was there got a lot out of it. What I thought I would do today, and what the original plan had been, was to advance on something we talked about in a previous session, and the financial outcomes that sometimes arise in the Employment Tribunal where there is a successful claim. And also to talk about the practical outcomes of where an organisation is perhaps not successful in the Employment Tribunal, where the claimant has succeeded, and what those financial remedies can potentially look like. The second half of today's session would have also been talking about how we then feed that back internally into an organisation. Unfortunately, I had hoped to have Nathan Andrews, our head of HR services, join me. He's not feeling very well. We didn't particularly want him coughing and sputtering through an hour, and I didn't particularly want to catch whatever he's got, so unfortunately he's had to drop out. So today's session I will focus almost exclusively on using the mock tribunal event that we hosted as a practical case study to talk about financial compensation, drawing on the hypotheticals and the sort of practical side of it from the theory in the previous session. So what today's session is actually going to look like, as I say, case study calculation of remedy in the Employment Tribunal where there's been a successful claim. As always, please do ask questions as we go. I can see the chat, I can see the Q&A as we're talking. I'll pick up on specific questions as we get to them. If there's anything kind of more general or anything that I think is more appropriate left until the end, then I will do so. There will probably be some time to run through a few questions towards the end of the session anyway. We're booked for an hour. It may well not be that long. So, as I said, we're drawing on the actual case study that the team and I used during the mock tribunal event last month. I appreciate not everybody on this call was there, so I will just run through briefly what that case study looked like. It was based on a female employee bringing a claim for constructive unfair dismissal and sexual harassment on the basis of sex as a protected characteristic. She was successful in both claims. The basic fact pattern in the background was that she had been exposed to not only sexually charged comments during the course of her employment, but had also walked in on two colleagues having an affair, and considered that in itself to be an act of sexual harassment. Having done that, she was also threatened with keeping quiet, and in response to all of this, she resigned, citing, of course, a breakdown in trust and confidence. Being threatened to keep something quiet, particularly at the risk of her job, was certainly considered to be a breach of that fundamental implied term, and the judge on the day did conclude that she had been sexually harassed, that there had been harassment on the basis of sex as a protected characteristic, and also that she had been justified in resigning. There had been a fundamental breach in that relationship, and therefore there was a successful constructive unfair dismissal claim. The one major thing we didn't get to on the day, largely due to lack of time, was the remedy. Those of you who were there will know that we had a live Q&A session running through as we went, and one of the questions that came up was what would the remedy have looked like in this case. As I answered on the day, we didn't get there largely due to time. We were trying to do in sort of 3 or 4 hours a tribunal case that realistically would probably have been listed for 3 or 4 days. And there is no guarantee that even at the end of 3 or 4 days the actual tribunal would have gone as far as remedy. It's not unusual for a tribunal to reserve judgment, i.e. to get to the end of the listed hearing and say we will write to the parties with our decision on liability, which usually then means a separate hearing for remedy if the claimant is successful, or indeed for the judgment to be delivered at the end of the listed hearing and then to have a new one listed just to deal with remedy. So even if we had got that far on the day, there's absolutely no guarantee that in a real situation, remedy would have been done at the same time. A few advantages of this for the parties. Firstly, that then does give everybody an opportunity to go away and potentially resolve the dispute, purely from a financial point of view, having had the liability already decided. There may be elements of the liability that are upheld and some which aren't, and that can guide financial settlement discussions. And it's not unusual, actually, for where there is this pause between the liability judgment and the final remedy for the parties to go away and financially resolve that themselves. Judges do often encourage it in those situations. Beyond that, of course, it means that the actual listed hearing can often be slightly shorter. What could have been a 7 or 8 day hearing to allow time to do that remedy may be listed as 5 on the basis that will only get as far as liability, and then the parties will sort out remedy themselves. So it was a realistic reflection that you may well not get to a remedy judgment just because you've got a liability judgment on the day. And that, of course, then also gives parties an opportunity to walk away, wind down from some of the emotion of the hearing itself, and be quite practical and pragmatic about what a financial resolution to the claim looks like. So with those two claims in mind, as I said, one of the big questions that came out is what would that remedy have looked like? And I've simply worked through what I think might have been a realistic outcome in this case. And of course, it's useful to all of you as well. It will cover claims that many of you will be exposed to at some point, that many of you may have already been exposed to at some point, and applies a lot of those principles that I was talking about in previous sessions. So, just some reminders. The constructive unfair dismissal element first. A constructive unfair dismissal is awarded in exactly the same way as an ordinary unfair dismissal. The calculation is the same. The only difference is the legal threshold that has to be reached to establish the claim in the first place. So there's no difference in remedy. Any unfair dismissal is broadly best thought of as a contract claim, really. It is a statutory contract claim. What we're saying is the relationship is broken down, the contract has been ended in a situation where it perhaps shouldn't have been. So the principle is we put the claimant in the position they would have been in had they not been unlawfully dismissed. And that's pretty much a contract claim. That said, it does carry a basic statutory award. It's same calculations as statutory redundancy payment to all intents and purposes. So that is the calculation based on the individual's age, weekly salary, and length of service. The longer somebody's been employed, the older they are, the higher that basic statutory award can be given at. The tribunal, on top of that, does also have the power to award compensation for financial losses of up to a year's salary, or the statutory cap on that, which is about £118,000 at the moment. So people who are on relatively short lengths of employment, who are quite young, who are on low salaries, they do not get awarded in unfair dismissal claims quite to the extent that people at the other end of those spectrums do. And to be honest, it is largely based on the idea that, in theory, the younger you are, the lower your salary, the easier it should be to find alternative employment. I'm not convinced that's entirely true all the time, particularly in the current market. But all of these unfair dismissal awards in particular carry this idea that the individual should be seeking alternative employment, should be trying to mitigate their loss. And that is something we'll come back to in this session, looking at the case study. Again, for discrimination compensation, just to recap, this is awarded again in two quite broad areas. We've got the injury to feelings element. Now, importantly, this is not a personal injury award. It is very much what is the psychological damage to this individual? How badly have they been made to feel by the discrimination? It is not a scientific calculation. It is very much an analysis by the tribunal of the claimant's evidence as to how badly they've been made to feel, and that can involve actual medical evidence. Their own submissions of the claimant's own oral or written evidence as to the impact on them of the discrimination, and also when it comes to giving a remedy judgment, the tribunal will often invite the representatives to make submissions based on existing cases. So similar cases with a similar fact pattern are often awarded in a similar way, but it is with the recognition that how somebody's made to feel is always subjective. As a matter of law, you take an individual as they are. If somebody is more inclined to feel more personally affected by something, they may well be entitled to a higher payment. The injury to feelings payment is based on these Vento guidelines, which I alluded to in a previous session. It's quite an old case now, and it was established to fix this gap in the law between personal injury and trying to give some kind of compensation for damages which are caused but don't necessarily meet the threshold of actually causing a personal injury. Personal injuries are calculated on a much more scientific basis. There are very complicated actuarial tables for that. This is much more. I don't want to say stick your finger up in the air and see which way the wind is blowing, but it can feel like that when the judgment is being made. I've set the lower bands out there, middle band and upper band. It is up to the parties to argue where that goes, and ultimately up to the tribunal. Realistically, you're often arguing where within a band something falls rather than which band it is. I won't go through them because they're pretty self-explanatory. Those figures get updated on an annual basis by the tribunal by presidential guidance. Secondly, the tribunal can then award financial losses caused by the discrimination, and this, as I was talking about in a previous session, is where you do get those much bigger, the massive compensation awards that we see. Loss of earnings caused by career loss, medical bills that might be caused by enhanced psychological injury, for example, if an individual has had to go through therapy, those kind of things, financial losses where they are caused by the discrimination, so loss of earnings, even historically, as I alluded to in a previous session. So that is just very quickly to recap the previous session. If you want more on the actual principles of how these are rewarded, please look back over the previous couple of sessions. So when we are looking at establishing a financial remedy, what we will often do as a claimant lawyer is set out a schedule of loss. We will often be instructed to do so by the tribunal itself. One may well have been done earlier, either on a without prejudice basis or openly, depending on how the litigation has been conducted. And there is some important information when you're doing this. I've used our actual hypothetical claimant details here. So Rita Tucker was our claimant. She was 24 at the time of the relevant events. We've got her length of service there at just over 4 years. We've got her pre-tax salary, which I've done as 25,000 just because it makes the maths easier. And there was a 4-week notice period which it was acknowledged in proceedings had been paid. That, of course, is relevant. She hasn't lost those 4 weeks. And the date of the hearing, 18th of June 2025, conveniently about a year after the termination date. It's almost as if we did that deliberately. These are all important because, of course, they play into the actual financial calculation for an unfair dismissal. They may also play into the financial loss element for the discrimination claim. And indeed, one way to think about the compensation, the injury to feelings element, is often to communicate it in terms of months loss, weeks loss. It's not scientific calculation, it's not how the tribunal will approach it, but talking about things in terms of months pay or weeks pay, that is how most of us think about money, and it can be a useful way to reach settlement, it can be a useful way to contextualise the figures that are being discussed. So, what might Rita's constructive dismissal claim have looked like? Well, there's her basic award calculation, her weekly pre-tax pay there being £480. That is well below the 719 week cap that currently applies to redundancy stroke basic award. We apply that multiplier in the same way that we do for a statutory redundancy payment. So she was conveniently 24 years old and had been employed for 4 years, which gives us a bit of maths to do here. 2 years where she was 22 or below, 2 years where she was over that age. So we've got 2 half years, 2 full years. She gets 3 weeks total. 3 lots of 480, 77 is 1442, 31. I would be very grateful if nobody double checks my maths here. I'm hoping I've got these right. Please don't. Moving forward to the compensatory element and what the tribunal might have awarded here. Well, they could have awarded up to a year's loss, but I think what we'll do just for the purposes of this calculation is assume she got a new job in 6 months' time. If she's got a new job on a roughly comparable salary, those losses do stop. It's only the actual losses that you're going to be awarded for in this compensatory element, or indeed for the discrimination element. You can't get awarded for losses that don't exist. So she's been out of work for 6 months, let's say, by this time. That's 12,500 pre-tax, as we know. It's roughly half of her salary. 4 weeks' notice becomes relevant here because that was paid. So it gets deducted from that figure. She's not going to be paid twice for the same period. She doesn't get her 3-month notice, her 4-week notice period, and loss of earnings for those 4 weeks. So it will be deducted, and that's quite correct. And that gives us a total of just over £10,500. Now, bearing in mind this is the constructive dismissal claim alone, we haven't even got onto the injury to feelings award yet. Our respondent in this case is already looking at an £11,000 or £12,000 payout, not counting all of their legal fees at this point. This is becoming very, very expensive already for somebody who was only earning £25,000. Discrimination and injury to feelings in our case. So the claimant is almost certainly going to argue here that discrimination has led to her dismissal. We may well accept that it is not an absolute top-end version of the Vento Awards. Those are reserved for pretty extreme, sustained and ongoing cases of discrimination. Again, there's no scientific way of deciding which band it goes into. It's purely experience. It's purely what you could convince a judge is going to be applicable here. I think realistically it's going to be in the middle band. My view, realistically, is that any form of discrimination which has led to dismissal, whether that's by resignation or active termination of employment, cannot be less than the middle band. I don't see how it can be a low band payment. I don't see how you can realistically argue that losing your job because of discrimination can ever be a low-level form of discrimination. So she's going to apply the middle band Vento Award, I would have thought. The astute among you will have noticed that 11,700 to 35,200 is not the figures I had on the previous slide. That's because we used the figures that were relevant at the time, and at the time it would have been the 2024 figures. So I suspect she's going to be arguing somewhere between 11,700 and 35,200 as her injury to feelings award in this case. As I said earlier, this is not a scientific calculation. This will be based on what the tribunal is convinced by the two parties, and their ultimate responsibility is to make an award that is reasonable, equitable, just in all of the circumstances. It is designed purely to reflect the emotional damage that is caused to the claimant by the discrimination. Now, usefully, the tribunal do periodically set out a table showing what their awards have been over the last quarter and then over the last year. The median sex discrimination claim in 2023-2024 was 16,100, which again you will probably have noticed is just below halfway between those two figures. It's slightly towards the lower end, actually. I tend to work on the median rather than the average award because, of course, the median knocks out the extreme examples at both ends. So that 16,100, for example, will not include the multi-million-pound payouts for sustained loss of earnings. It is an average of an average to all intents and purposes. I'm not a maths teacher, you might have noticed, but there is a difference between the median average and what most of us think of as an average. That all said, there is an aggravating factor in this case, which is the fact that she was threatened and resigned. That was potentially a discriminatory dismissal in its own rights. I do think that justifies pushing the figure up slightly here. The tribunal, in their judgment, were quite scathing of the organisation. It wasn't handled particularly well, and I do think that threat is particularly egregious in the circumstances. Particularly on the back of the fact that she had experienced sexual harassment in the past. All of these things are going to be relevant. Anything that the tribunal thinks it should consider can be relevant, and we are talking about the overall impact on the claimant. If she is particularly sensitive, tough, it doesn't matter. It is about the impact on her as an individual claimant. So let's look at some subtotals here. Subtotal there of the basic award and compensatory element, as I said, we're talking about £12,000 there. That's already quite a significant figure. We're halfway to her annual salary to all intents and purposes. And for the discrimination claim there, again, this isn't a scientific calculation. That 23,450 is the exact middle ground between 11,700 and 35,200. I think that's a perfectly acceptable figure to put forward to the tribunal for the purposes of arguing. It may well have been higher in previous correspondence. It may well be higher in the actual schedule of loss. But there we are. We've got a subtotal of £35,500. We're now talking about a figure that is higher, £10,000 more than her annual salary. I've had one question asking when the Vento bands go up. They're reviewed annually at about the same time as all of the other statutory figures, so it's usually around the start of the financial year. So, yes, quite a significant amount of money here for our claim. We've got all of the legal costs on top of this. We've got a financial value that could well be more than her salary was anyway, for what those of you who were there on the day will know was probably a totally avoidable claim if it had just been handled properly. So, moving on from that, of course, it's not just that basic calculation. There are other things that we can factor into this and that the claimant is perfectly entitled to argue. ACAS uplifts are applicable in so many situations now and will increasingly be in the future that it's really important to be aware of them. Fortunately, not necessarily applicable in this case. So the ACAS uplift usually applies where one party or the other has failed to comply with their minimum standards for a grievance or a disciplinary process. Those of you who were there will know that our claimant did raise a grievance, but that she did so in her resignation letter, having resigned with immediate effect. So there was no obligation to carry out a full grievance investigation at this point because she was no longer employed. There was also kind of an argument really as to whether she'd even raised a grievance. She certainly hadn't historically. So the ACAS uplift is probably not going to apply in this case. Now, slight caveat to that, of course, the new duty to prevent sexual harassment when all of that rolls in, and there will be an ACAS code for that. That ACAS uplift will apply to any claim to which a sexual harassment element is attached. So in our case, if it was being heard in a couple of years' time, there would potentially have been the ability to uplift the entire award on the basis that the company had not taken those reasonable steps to prevent sexual harassment in compliance with its new duty. And again, it works in exactly the same way. That is an uplift of up to 25% of all relevant attached claims and associated awards. A claimant can also bring a claim for financial interest on a discrimination element. There's two slightly different ways of calculating it depending which bit you're claiming for, but in this case the important thing is it's 8% per annum prorated between the date of the discriminatory event and the hearing. And that's the important one for our calculation at the moment. So we've already now got an uplift given we had almost exactly a year, just for the sake of making numbers easier. The overall payment could well be uplifted by a further 8%, purely because statutory law says if she's got a payment, she can claim interest on it. So, what does our claimant schedule now look like? Basic award, £1,400, compensation award, £10,500, injury to feelings, just under £23,500, a year's interest on that, another £1,800. We're now suddenly at £37,000. We're at 50% more than her annual salary. Again, for a claim that was entirely avoidable, not to mention legal costs. And again, this is a realistic calculation for the claim that we had in front of us. I don't think that's an unusual figure at all. It's certainly around the figure that I would have argued much earlier in this case if I'd been acting for her and negotiating on a without prejudice basis, for example. And indeed, if that figure had been put forward to a respondent a year earlier, settling this claim for 15 or 20,000 even would have been financially justified in this case. Don't forget their legal costs could well be in the region of 20 plus. So we're talking about the overall cost of this case at the moment pushing sort of 60, 70 odd thousand pounds. I don't know why I've just jumped to the next slide there. I think what we can talk through very briefly, just for 5 minutes, given we've got some time, is what the respondent might be saying about some of these figures. So if we move back through them, we can maybe have a look at some of the things the respondent will be saying. There's not an awful lot of arguments over the basic award. This is a simple statutory calculation. There are very, very few ways to argue that. The only way to challenge it is to argue the overall compensation figure, which I'll roll forwards to in a moment. We've calculated the compensation figure based on 6 months of being out of work. That's fair enough. She factually was on paper. The easiest way to challenge this, as we've discussed previously, is to say she didn't need to be out of work for 6 months in total. And if you're bringing and dealing with just an ordinary unfair dismissal, one of the first bits of advice we will give you from the moment the individual has gone is start compiling jobs you think they could be applying for. One of the easiest ways to reduce an unfair dismissal award is to focus on what the claimant should have done to mitigate that loss. Could they have got a job in 3 months? Turning up at a remedy hearing with a pack of 50, 60 or even more potential jobs an individual could have claimed for. And the examination is, in effect, did you apply for this one? No. Did you apply for this one? No. Did you apply for this one? No. You're starting to build this idea that they've not made reasonable efforts to mitigate their loss. The problem you have where an unfair dismissal is tied to a discrimination claim, of course, is the employee is inevitably going to argue, I was so traumatised by the discrimination, I didn't feel as though I could start applications. I wasn't very good at interviews because I was so concerned about recovering from the way I was treated. And that then becomes an overall question of how much damage was caused to the individual here, how reasonable is it in the circumstances to award them. The difficulty for the claimant in bringing that argument, of course, is it starts to conflate their loss of earnings caused by the constructive dismissal with their overall financial losses. Tribunals don't like awarding people twice for the same thing. So a claimant has to be very careful about how they argue that. Obviously, the best way to try and reduce the overall payment here is to target the biggest figure, which is the 23,450 here. We will be trying to argue as a respondent representative that that is too high, that the kind of emotional damages caused to the individual are not as serious as she was describing, that she's being overly sensitive, and that was something that came across in the cross-examination, the oral evidence on the day. Those of you who were there will know that the respondent's representative was actually pushing quite hard on that. You know, you've walked in and seen something that was none of your business. It wasn't a particularly extreme sexual act that you walked in on. It was just 2 people kissing who were having an affair. A lot of us would say that that was not a particularly great thing to walk into, but overall relatively trivial in the grand scheme. There were questions with her evidence, of course, but we can't challenge the facts. The tribunal did establish that she saw these things, that the harassment happened. So our only line of argument is about the impact on her. It is, of course, for the claimant to prove that. They are going to have to give evidence to that effect. They are potentially going to produce medical evidence if they're arguing they've been psychologically traumatised. And those things can be very, very difficult to challenge. In much more high-profile cases, high-value cases, you may well be looking at getting conflicting medical evidence even as to just how seriously the individual has been affected. And unfortunately, it's one of those situations where a cost-benefit analysis does have to be undertaken as to the extent to which it is worth making this argument and fighting and pushing. For what it's worth here, yes, we could probably argue the 23,450 acting for a respondent and exactly where that sits, but I don't think there's going to be any scope to argue that this case was not somewhere in the middle band. So what we would probably be looking for is you'd be relying on your solicitor if they're in court for you, or a barrister if one is instructed, to find similar cases where there was a significantly lower compensatory award made. And those really are the only lines of argument in this case. The interest calculation is there, that's just established in law. She's more than entitled to claim that, not a huge argument that we could have there. And I think you'd probably struggle in this case to end up with the overall figure being much less than somewhere around 25 to 30. And then when you think about what I was saying earlier and taking that back to the start, talking about this in terms of months, weeks, or even a year's loss, there is an absolute argument here that this case could have been settled much earlier. It was all avoidable. The respondent's approach to this was not great, probably for significantly less money overall. And it feels like I'm sort of talking us out of work here. We do enjoy the tribunal work. We do like taking cases to court. That's why we do what we do. But in terms of the respondent's best interests here, a very early assessment of this potential value could and should have been carried out with a view to settling much lower. Now, obviously, there's no guarantee the claimant would have accepted that. There's no guarantee that they'd have been prepared to settle for lower. Their own representative may well have told them that this claim was much higher. Again, let's not forget we've gone in at 23,450 there for injury to feelings. Her representative could have been telling her this claim is worth 35,200 or more, plus the interest, plus the unfair dismissal elements. So I think the point is really this is not a scientific calculation necessarily. Settlement certainly isn't, and nor indeed is the ultimate award at the end. But for those of you who are there, you may be surprised by the height of this figure, given how closely we were balanced on who was at fault as part of the voting and polling process on the day. And as I've been saying throughout, let's not forget there could well be £20,000 to £25,000 worth of legal costs on top of this, bringing a totally avoidable situation coming to cost you somewhere in the £60,000 mark. So I said today would be a slightly shorter session. That is all I had to particularly say on this one. I'm happy to have a conversation to answer any questions as they crop up about how this award might have been calculated, about how the case itself might have gone differently, any questions that were still arising from the mock event itself from anyone who's on the call and wants to ask anything about that or about financial awards generally. If not, next session we will do one in August. I appreciate people will start being on leave. We'll try and keep that one as a slightly more informal event. I think what we'll probably do is I'll try and get Nathan on board for that one, bless him, and have the conversation we were trying to have about learning outcomes from an unsuccessful tribunal and how that feeds back internally. But at the moment, topic still to be confirmed. If anybody's got any suggestions or anything they do want us to talk about, please let us know. For those of you who haven't yet, please do also save the date. Our next in-person Employment Law Update seminar is Wednesday the 24th of September. Down here, we're in Christchurch at the Captain's Club. The focus will be on the Employment Rights Bill and what is going on with that at the moment. No doubt you've been getting a load of emails from all sorts of people telling you about periodic updates, changes to the draft. I know I posted on LinkedIn that the roadmap to implementation has already been circulated, so we'll have a conversation through that, talk about what it's looking like at the moment. Should be a good event. We may well pepper it with a few other things as well, just so we don't have to talk about speculative legislation change for 3 hours. But again, that should be a fantastic event. We always enjoy our in-person ones and seeing as many of you there as possible. But otherwise, as always, thank you for joining me this morning. If anybody's got any questions, please do. I'm happy to hang around for a moment and answer those. But if not, thank you for joining us and have a good rest of your day, rest of the month. Those of you who are going away, enjoy. And we'll catch up in August. And if not, I will see you in September, I'm sure. Thank you, everybody.